Hello all, good day. Now I am talking about second video on law of evidence. The exam topics here are given here below. Now let us see the basic uh, concept on evidence. Evidence is derived from Latin word evidentia, meaning to show clearly or to prove. The word evidence is used in common parlance in three different senses: as equivalent to relevant, as equivalent to proof, as equivalent to material, on the basis of which courts come to conclusion about existence and non-existence of the facts. The term evidence has been defined in interpretation clause of Indian Evidence Act as the evidence means and includes all statements which the court permits and requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence. Thus, the law of evidence is the body of legal rules that inter alia governs what facts need to be produced and proved before the court to enable it to make a decision which are the parties have an obligation to prove a fact, what is the required standard of proof to win the case, the admissibility, credibility, weight of evidence and allied procedural matters and are concerns of law of evidence. Lex fori. The law of evidence is lex fori. Fori means court. Lex means law. The rules in law of evidence play very important part in the course of trial, whether it's civil or criminal case. Since it deals with procedure, it is part of objective law. The law of evidence, however, is part of the law of procedure, that is, the procedure which a court has to follow. This is expressed by saying that it is the law of the forum or court or lex fori. This is purely a matter of convenience. It means that even if a fact to be proved in an Indian court is one that occurred in another country, it shall be proved in accordance with the Indian law of evidence. In case Niharendu versus King Emperor, the fact has occurred in England and law applicable is Indian law of evidence. Civil and criminal versus evidence. The method of proving that a particular person is dead, whether the question arises in a civil or criminal proceeding, is the same. However, there are certain differences. Sections that apply exclusively in criminal cases are 24 to 30, deal with confessions, 53 to 54, the character of an accused person, 120, competency of a spouse as witness for other spouse. Section 153 to A and 155 says character of the prosecutrix in cases of rape or attempt to ravish, that is assault. Before the accused is convicted, the evidence adduced by the prosecution should not only make the guilt of the accused highly probable, as it is commonly expressed, the prosecution must prove its case beyond all reasonable doubt. Sections applicable to civil laws are Section 52 and 55, character of the parties. Section 115 to 117 is estoppel. The mere preponderance of evidence is sufficient in civil cases. Let us see the history of law of evidence. In the past, all the irrational methods have been used for ascertaining the guilt of the person or the right of a person to property. Trials by battle. Trial by battle was abrogated in English law by statute only in 1817. Trial by ordeal. Hot iron and boiling water methods were believed to be superstitious, that the innocent person would not be burnt or scalded. The priests in this time were using tricks to save the persons of their interest. During the 18th century, the corpse touching method, that means the corpse will show reaction when touched by guilty person. The reaction is evidence given in the past, like opening eyes, pointing finger, oozing blood, etc. Witchcraft trials. In this, the victims usually were old men. This was followed during 16th century. Lie detectors, truth drugs were used nowadays. In India, our ancient texts dealing with law have elaborated the rules, but one cannot say how far they were practiced. During the Islamic period, no historical material evidence to say what rules are followed. During the British period in around 1726, first step of application of rules which were there in England applied into India. Sir James James Stephen passed bill which was approved and became Act 1 of 1872. This came into force on 1st September 1872. It contains law of evidence in India. This law was adopted in all princely states in India. Later, after independence, Indian Evidence Act is the law relating to evidence in all courts of India. The objective of Indian Evidence Act was to consolidate the then prevailing rules of English law of evidence with few exceptions. It goes to the genius of Sir James Stephen that in the 145 years of existence, the Indian Evidence Act has been amended only few times, and probably there has not been any question before the Indian court regarding evidence for which the Indian Evidence Act does not have an answer. Where the Indian Evidence Act is excluded, the Indian Evidence Acts extend to the whole of India and applies to all judicial proceedings in or before any court. Court martial convened under the Army Act 1950, the Air Force Act 1950, and Navy Act 1957, subject to the provisions of those acts, but it does not apply to affidavits presented before a court or officer and proceedings before an arbitrator like departmental inquiries, internal inquiries, proceedings before industrial tribunals and other tribunals, inquiry commission and Income Tax Act 1961. Coming to judicial proceeding, it is not defined in evidence law. Its definition is in Criminal Procedure Code section 2(1). It includes any proceeding in the course of which evidence is or may be taken on oath. Any proceeding which is judicial only when its object is to determine the legal relationship between a person and any other person, between a person and group of persons, or between him and the community generally. Affidavits. It is not defined in Indian Evidence Act 1872 but defined in General Process Act 1897. It includes affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. These are governed by CPC and CRPC provisions. Types of evidence. These are different types of evidence which will be discussed later. Admissible and inadmissible evidence. The evidence which is admissible is necessarily relevant as per the provisions of the Indian Evidence Act. Facts should not be received in evidence unless they are both admissible and relevant. Rules on which evidence becomes inadmissible. The evidence of relevant facts are inadmissible when its reception offends the public policy of or rule of law. Relevant facts are subject to recognized exceptions, inadmissible unless they are proved by the best evidence. What is best evidence? This idea is implicit in Indian Evidence Act. It implies that only the best available evidence should be allowed in the court. The best depends on the available peculiar facts and circumstances of the case. The circumstantial evidence is a close companion of the factual matrix, creating a fine network through which there can be no escape for the accused. Oral evidence. It means all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. As a matter of rule, the oral evidence must be direct. It is also referred to as testimonial evidence. It must be direct if it refers to a fact which could be seen, heard, or perceived. If it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Real evidence. It is covered by the second proviso to section 60, which says provided also that if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. Example: weapons, scars of wounds, injuries on body. Presumptive evidence. The court shall be furnished with best available evidence, should be furnished with best available evidence. The court should not be left to banks upon presumptions unless the science has no power to the facts in issue. Where there is a conflict between conclusive proof based on a presumption and a proof based on scientific advancement accepted by the world community to be correct, the latter must prevail over the former. When the truth or fact is known, there is no need or room for any presumption. Hearsay evidence. It is not taken as relevant evidence because the person who is giving evidence does not feel any responsibility. Truth is diluted and diminished with each repetition. If permitted, gives ample scope for playing fraud by saying, "Someone told me that." In case of Kushal Topo versus State of Jharkhand, the Supreme Court found that the evidence relating to extrajudicial confession made by accused Mahendra was found in two places in the evidence of PW2, that is paragraph 8 and 27. Therefore, it is clear that the PW2 got information from PW1. Corroborative evidence or supportive evidence. It must be taken along with the substantive evidence. There are several statements, oral, documentary, which are not substantive in nature. They become admissible to corroborate or support or substantive evidence already given. Corroboration can be received even through the circumstantial evidence and not necessarily by direct evidence. Section 156, 157 and 158 gives permission to submit the evidence to corroborate substantive evidence. Documentary evidence. Document is defined in Section 3 Indian Evidence Act as any matter expressed or described upon any substance by means of letters, figures or marks or by more than one of those mean intended to be used or which may be used for the purpose of recording that matter. Example, a tree on which a particular number is inscribed is a document. The genuineness of the documents or truth of contents, that is, statements contained in document, is proved by oral evidence. Example, the production of newspaper only proves what the newspaper contains and not that what it says is true. This is in accordance with the section 58 and 61 to 65. Section 59. Section 59 says proof of facts by oral evidence. Section 61 says proof of contents of documents. There are two rules connected with the documentary evidence, namely Section 163 giving and as evidence of document called for and produced on notice. It is related to production of documents before court by one party when the same is asked by other party. Section 164 says using as evidence of document production of which refused on notice. When a party refuses to produce a document when he has had notice to produce, he cannot afterwards use the document as evidence without the consent of the other party or orders of the court. Primary and secondary evidence. Section 62 defines primary evidence and Section 63 defines secondary evidence. Section 62 primary evidence means the document itself produced for inspection of the court. Where a document is executed in several parts, each part is primary evidence of the document. Illustration. A person is shown to have been in possession of placards, all printed at one time from original. Any one of the placards is primary evidence of the contents of the other, but none is primary evidence of contents of the original. Secondary evidence means and includes certified copies, copies made from original, copies made from or compared with the original, when the original have been proved to be admitted in writing by a person against whom it is proved or by his representative in interest, when original is lost or destroyed, or when party offering evidence of its contents cannot for any reason not arising from his own default or neglect produce it in reasonable time, when the originals is of such nature as not to be easily movable, when original is a public document within the meaning of section 74. Section 65 specifies what kind of secondary evidence will be received in various cases when secondary evidence is permitted. Case Nawab Singh versus Indrajit Kaur. The original rent note was not produced by the defendant, who was alleged to be in possession despite several adjournments. The plaintiff sought to produce secondary evidence, but the trial court rejected it on the ground that the copy is of doubtful veracity. The Supreme Court held that the plaintiff should be allowed to produce the secondary evidence, and then the court may pronounce on its veracity. Electronic record. Admissibility of secondary evidence of electronic record depends upon the satisfaction of the conditions as prescribed under Section 65B. Accidental or incidental evidence. Incidental evidence facts under Section 15 Indian Evidence Act. The accident and incident share the idea of a sudden and unpleasant occurrence. Accident usually referring directly to something that causes damage or injury. Incident referring to a specific moment or instance of unpleasantness or unlawfulness. Accidental refers to something happening by chance, but also something implying inattention or carelessness. Example, an accidental discovery. The timing was accidental, an accidental fire. Incidental means minor or when it means by chance or without intention or calculation. The idea of carelessness is absent. Incidental expenses played an incidental role, an incidental finding. Coming to Section 115 Indian Evidence Act, the facts bearing on question whether act was accidental or intentional. When there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. Illustrations. A accused of burning down his house in order to obtain money for which it is insured. The fact that A lived in several houses successively, each of which he insured, in each of which a fire occurred, and after each of which fires A received payment from a different insurance office, are relevant as tending to show that the fires were not accidental. A is employed to receive money from the debtors of B. It is A's duty to make entries in a book showing the amounts received by him. He makes an entry showing that on a particular occasion he received less than he really did receive. The question is whether this false entry was accidental or intentional. The facts that other entries made by A in the same book are false, and that the false entry is in each case in favor of A are relevant. A is accused fraudulently delivering to B a counterfeit rupee. The question is whether the delivery of the rupee was accidental. The fact that soon before or soon after the delivery to B, A delivered counterfeit rupees to C, D, and E are relevant, as showing that the delivery to B was not accidental. The competence of child as witness is dealt under Section 118. Section 118 of the Act states the person who can be a witness. The court identifies all competent individuals who can testify with proper knowledge of the crime. There are restrictions placed in consideration by the court on those who are incompetent in understanding the questions put to them. These include by tender years, extreme old age, disease, whether of body or mind, or any other cause of the same kind. The condition of the witness does not bar him from testifying, but his incompetency to understand the questions or answers rationally exclude him from being a witness. Child witness and admissibility. Child witness. A child who has the understanding of the questions of the court or has the rational answers to the questions put forward can testify in a court as per Section 118 of the Indian Evidence Act. Admissibility of a child witness in a court of law. The testimony by a child in a court of law is not given much importance due to the possibility of the coercion induced statements which would threaten the authenticity of the witness. A child can have different perspective to different situations according to their mental development. The maturity of every individual is subjective to the environment he or she resides in and the socio-economic development of that individual. Principle of Wall-Dyer test. This test was established to identify the competency of the child to be a witness according to the conditions provided in Section 118 of the Indian Evidence Act 1872. The child can be asked some questions out of the scope of the case details, which include preliminary questions on name, father's name, or their place of residence. If the court is satisfied with the answers of the questions, the capability of the child to understand the questions and answer them rationally can the child be allowed to testify in court. Case laws. The Supreme Court in Dattu Ramarao Sakre versus State of Maharashtra held that if the court finds element of truth in the testimony after careful scrutiny, then it should not be left out to be admitted as evidence. It is believed that child witnesses are more prone to torturing by their elders. The court in A. Pradipan versus State of Kerala opined that if a child is able to appreciate and acknowledge the questions put to him and he is able to revert back rationally to such questions, then definitely the child witness is capable to give evidence in court of law. Plea of alibi. Introduction. Alibi is a Latin word which means elsewhere. It is used when the accused takes the plea that when the occurrence took place, he was elsewhere. In such a situation, the prosecution has to discharge the burden satisfactorily. Once the prosecution is successful in discharging the burden, it is incumbent on the accused who takes the place of alibi to prove it with absolute certainty. Plea of alibi. It is the plea of absence of person charged with an offence from the place of occurrence at the time of a commission of the offence is called plea of alibi. In criminal law, this plea is used by accused against the commission of an alleged offence. When the accused pleads the alibi in court of law, he or she attempts to prove that he or she is somewhere else at the time when the offence is committed. Section 103. When the accused took the place of alibi, the burden of proof lies on him under Section 103 of Indian Evidence Act. If a person is charged with murder, he is to prove that he was elsewhere. The plea of alibi has to be taken at the earliest opportunity and it has to be proved to the satisfaction of the court. When our alleged offence has been committed and the prosecution accuses a person of having committed the same, it would be a complete answer to the accusation for that person to plead that he was at that time elsewhere. If that person succeeds in establishing that plea, technically called the plea of alibi, he will be entitled to an acquittal. Illustration. A is accused of B's murder on a particular date at Delhi. On that day, A was at Pune. Is relevant to prove the plea of alibi. Now, A will prove that it would be impossible for him to commit murder at Delhi as he was in Pune. Who may take a plea of alibi? Generally, the accused of an alleged offence takes the plea of alibi. The accused must plead his presence elsewhere at the time of the commission of alleged offence. When to raise the plea of alibi? In order for the plea to be successful and effective, it is always advisable to make the plea at the earliest or in the initial stage of case. This stage could be at the stage of framing of charge or at preliminary hearing. Failure to establish alibi. Failure on the part of the accused to establish plea of alibi does not help the prosecution and it cannot be held that the accused was present at the crime scene. The prosecution must prove it by positive evidence. Thus, mere failure on the part of the accused to establish the plea of alibi shall not lead to an inference that the accused was present at the crime scene. In Binay Kumar Singh versus State of Bihar, it was that plea of alibi is not an exception that is special or general enumerated in the Indian Penal Code or any other law. It is a rule of evidence provided in Section 11 of Indian Evidence Act that facts which are inconsistent with the fact in issue are relevant. Lakhan Singh and alias Pappu versus the State of NCT of Delhi. The plea of alibi cannot be equated with the plea of self-defense and the ought to be taken at the first instance and not belatedly at the stage of defense evidence. Best of luck. Thank you. Please like, share, comment and subscribe.